Hello, my name is Jeff. This is 2A Self-Defense Law. What we do is we help people understand the law of self-defense in the simplest terms possible. What we do is we give you the least amount of information possible, if that sounds weird, to give you the greatest effect. So you're the cause and effect. The small amount of cause is going to have the greatest amount of effect, and that is innocence, imminence, proportionality, avoidance, and reasonableness. If you master those, you have a great shot of getting through the legal system with not too many scrapes. You guys have been asking me about active self-defense again, active protection, or whatever his name is. He's just exploding on the scene, and his videos are creeping into other classes that I've been into. People have been asking me about his information. I don't watch all his videos. If it is an interest to me, if I come across it, yeah, I will watch it. But for my understanding, he went into credibility. People who need to have a certificate or certification to give self-defense law advice. Again, I don't give self-defense law advice. I give self-defense educational advice. Again, I'm not a lawyer. I don't claim to be. And I am a true believer that there are lawyers who are certified by the state to be lawyers and also give horrible bad advice when it comes to self-defense law. You know, I'm not going to be cracking on lawyers. And I just want to make you guys to be aware that even if you are certified, you have a piece of paper that says you are qualified to give informational advice. Well, I'm not a lawyer. Again, I don't claim to be. I'm not certified by anyone, but guess what? In some areas, I know more than what lawyers do. And this is not cracking on lawyers or trying to blow up my head. There are criminal defense attorneys that do a good job for criminals. We've talked about this before. Somewhere north of 97% of all self-defense cases are crap. They are a criminal trying to use the system to get off, and the lawyers over the years have decided that there is a specific way to get criminals through the system and get them off charges or technicalities or that thing, and that is a bad advice because self-defense is an affirmative defense. It is that, yes, I may have shot and killed somebody, but it was for self-defense reasons. There are courts cases that build up when you say it is a self-defense case too far down the road. You actually have to tell the judge that this is going to be a self-defense case. You can't just go to trial and hope and pray that one lawyer says, I'm so good and I've seen lawyers so bad that they can't even get your gun into evidence. Well, you're going to have to tell the judge that this is a self-defense case before you even go to the court. Don't let that go too far because you will start looking like a criminal. So my main point is look for the people that are given this kind of education out there. Take that education out there and go confirm it for yourself. Yes, I've been wrong in some areas, but it's because of a factual error in information. Self-defense is highly factual, and anything that is factual can change an element of self-defense in whole or in part, and I'm not really going to get into that. Again, the more we get into the weeds as far as you concealed carry weapons people out there, the more that you get into the weeds, the more anti-fragility comes into. What anti-fragility means that if you rely on your self-defense case on a stand your ground or a reasonable perception, a presumption of innocence, fear, proportional, whatever that is, all that stuff can be taken away from you. I'm going to have another video on that particular specific topic. So I want to make clear that you understand that good guy self-defense cases are tried differently. You need to come up with the information saying, hey, that was the bad guy, the witnesses are over here, this is what happened to me, these are the defensive scars. Whatever the connection can be, let your lawyer build that narrative for you, but it has to be at a reasonable amount of time, because you cannot just shut up and not say anything. If you saw a knife that slid under, if a guy with a knife was attacking you, and you had to shoot the person, and that guy dropped the knife and it went into a river, I'll just make something ridiculous like that. You were doing this on a bridge and it went into a river. Are you not going to talk and tell the police that the guy who attacked you with a knife on the bridge dropped the knife into the river? Are you not going to say that? Isn't that direct exculpatory evidence that you were in fear for your life or great bodily harm? Those are the differences between what a criminal defense lawyer does and a lawyer who understands and appreciates a good guy self-defense case. Now, the other, and I'm going to be tiptoeing around this because it is a great community. I've talked to, I don't know, probably about 60 to 80 police officers over the last 10 years about self-defense claims. The worst group, other than just internet forums to get your self-defense law information, is going to be the police force. And this is going to be why. A civilian needs up to 5 standards: innocence, eminence, proportionality, avoidance, and reasonableness. The police do not need to have all that. So do you believe that when they're going through training in the police academy or on their force, that they're going to be talking about the innocent standard? The police have already been assumed to be an innocent party. They don't have the same requirements that we do with the innocent standard. The next standard that a lot of us have is avoidance. Police do not train or talk about avoidance. Because why? They have to engage the people, right? They have to control the situation. There is nothing that the police really have to use as far as a duty to retreat. The last standard is reasonableness. The police have departmental policy that tells them what to do. And the only time that it goes outside of those bounds of reasonableness is when they break policy. Now, I've talked to a lot of cops about departmental policy, and this is what they said, that they don't feel that departmental policy is there to protect their lives. It's there to protect the city from a civil lawsuit. So when you talk to the police department, or police in general, innocence, duty to retreat, and reasonableness, those standards, they rarely will talk about it because their police policies, you do not need that, except for reasonableness. But if you break a policy, then you have broke reasonableness. So that's why I say the police officers are well-intentioned people, but in general, they will not give you the complete picture that a civilian needs to have for self-defense. They are very good on proportional force, and they are awesome on immediate. When they talk about that stuff, listen to it. It is good advice on those two standards because they pretty much are into those standards every single day. But when it comes to innocence, no. They don't know anything about what a civilian needs to do for innocence. They don't talk about duty retreat. They do not talk about the reasonable person standard in the forms that really needs to have. They will talk about the AOJ triad, but that goes back toward proportional and eminence. Now they call it something different. Sometimes they'll call it the AOI, ability, opportunity, and intent. I don't get into intent that often because that is a legal subjective term. So when you get your information on self-defense law, understand where it comes from and what the forces are behind it. My name is Jeff. This is 2A Self-Defense Law. I hope this helped.